You're listening to The Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. This series is hosted by litigation attorney Dan Small. Listeners of this series will gain a fresh perspective on how attorneys can address various trial preparation issues and set themselves up for success in and out of the courtroom.
There are many ways to attack a witness's credibility. Opportunity to observe. Was it too far or too dark for the witness to see? Bias. Does the witness have a prior history, good or bad, with one of the parties? Character. Has the witness been convicted of crimes or other things that would affect his character or her character? Contradictory evidence. Are there documents or other evidence that contradict the witness's story? And lots more. One of the classic challenges to a witness's credibility is the prior inconsistent statement. Somewhere along the way, the witness had said something in a statement, deposition, tape, wherever, that contradicts their testimony at trial. One of the keys to a successful cross-examination is knowing how to effectively use that prior inconsistent statement. For that purpose, I learned from great lawyers and great teachers to use the 3 C's: commit, credit, and confront. Commit the witness to the current statement, usually the direct examination if it's at trial. Credit the prior statement, and then confront with the contradiction. In the Farmers Export Grain Elevator explosion trial that we've talked about in the past several episodes, the defense started off claiming they had done nothing wrong. This was absurd. But as witness after witness talked about how dirty the grain elevator was, with piles of grain dust everywhere, and how management was pushing so hard to dump rail cars faster and faster that sparks were flying, they fell back on 2 other lines of defense. First, intent. Okay, well, maybe they screwed up, but they're not criminals. They didn't intend to hurt anyone. And second, motive. This is really just a dispute between labor and management. To some extent, that second one is how it appeared. The laborer witnesses talked about how bad things were and how little management cared about safety. The management witnesses talked about how clean it was and how safety was their highest priority. So imagine defense counsel's delight when they found a witness who bridged that gap. We'll call the bridge witnesses Billy. Billy had been a laborer at the time of the explosion, but had since been promoted to management and now supported management's story all the way. I don't have the transcript or exhibits, so all this is from memory, but my memory is pretty clear. Basically, Billy testified on direct that management was very conscientious. Cleaning crews were sweeping the elevator regularly. The elevator was so clean you could eat off the floor. Safety was the highest priority, and they were very careful in the rail dump. On the night of the explosion, it just happened that OSHA investigator Don Donnelly happened to be driving in Galveston and heard about the blast on his police scanner radio. He raced to the chaotic scene and was there with the first responders, immediately starting to interview witnesses. That night, Don had in his car a pad of simple 1-page interview forms. At the top, after the witness's name, it said something like, "I voluntarily and willingly make this true statement." The middle had space for Don to write up a brief statement. Then at the bottom, above the witness's signature, it said, "I have carefully reviewed the above statement, and it is true and accurate. Signed under pains and penalties of perjury." Short and sweet. On the night of the explosion, Investigator Donnelly had interviewed Billy and had him sign a statement. In the chaos of the long night, Billy had long since forgotten. I had actually considered calling Billy as a government witness, but I was told no, that he had gone over to the dark side, so I didn't call him. When I first saw his name on the defense witness list, I searched my soul, and by the way, more than a few law books, about whether I had to turn over his statement. In a criminal case like this, if someone is a defense witness, the government is generally not obligated to turn over that witness's statement unless it's exculpatory, which this certainly was not. So I thought long and hard, lost some sleep, and didn't turn it over. I kept the statement buried in my file and waited for the cross-examination. Was I nervous? No, I was scared to death. Are you kidding? Lawyers can go their whole career without being handed a setup like this. Yet here I was, 2 years out of law school, and scared that I would blow this opportunity, and with it, my case. All I could think of as I sat there were those 3 words: commit, credit, and confront. Again, there is no transcript or exhibits left of the cross-examination, but here's my memory in a much condensed form. The first C is commit. I asked Billy to confirm, you testified for the company today. Yes. You're now part of company's management. Yes. You met with the company counsel before you testified today. Yes. Billy confirmed all of the above, so I continued by having him make his statement about the work conditions of the grain elevator and the management style of the company at the time of the explosion. His claims matched those of members of management who testified before him and confirmed his testimony on direct. Management was conscientious. Safety was their highest priority. Cleaning crews swept the grain elevator regularly. It was so clean, you could eat off the floor. I particularly like that one. Now that Billy had committed to his current statement, to his direct examination, it was time for me to credit the prior statement. So I asked him about his memory of the night of the explosion. I asked, there were rescue workers, firefighters, and investigators on site that night. Billy said yes. Interviewing witnesses is a key part of any investigation, isn't it? Yes. It's important for witnesses to tell them the truth. Yes. They have to know the truth so they can try to prevent it from happening again. Yes. 18 people died that night. Yes. You wouldn't want that to happen again, would you? No, I wouldn't. Did you lie to the investigator that night? No, absolutely I didn't. Would you lie to an investigator? No. There was an OSHA investigator there that night who interviewed witnesses. Do you remember that? No. Ask Agent Don Donnelly to stand. Sir, do you recognize Mr. Donnelly? No, never seen him before. Actually, he interviewed you the night of the explosion and wrote down what you said. Do you remember that? No, never happened. He asked you to read it carefully and sign it. You don't remember? No, that's ridiculous. Sir, this is Exhibit 35 I'm handing you. Do you recognize your signature at the bottom of the page? And there was a long pause. And then very quietly, Billy said, Yes, I do. You signed this under oath, just like the oath you took here, didn't you? Yes, I guess I did. You signed a sworn statement verifying that the information was true and correct. That's what it says, right? Yes. And you knew how important it was to tell the truth. Yes, I guess I did. Then came the final C, confront, to compare the sworn statement he said at the trial on his direct to the sworn statement he made the night of the explosion. I linked his direct to the company. Your statement for the company today was management was conscientious, right? Yes. But your sworn statement that night, with 18 people dead, was all management cared about was making their quotas. Yes, I guess I said that. Your statement for the company today was cleaning crews swept the elevator regularly. The elevator was so clean, you could eat off the floor. That's what you said, isn't it? Yes, that's what I said. Your statement that night, the night of the explosion, was that crews had been taken off cleaning assignments to dump more rail cars, and there were piles of grain dust everywhere. That's what you said that night. Yes, I guess it is. Your statement for the company on direct was safety was the highest priority. You remember that testimony? Yes. On the night of the explosion, with 18 of your friends dead, you said there was competition between the shifts to dump the most rail cars, that sparks were flying from rail cars being banged together. Do you see that here? Yes, sir, I do. It was an amazing experience. Billy was completely caught off guard and totally flummoxed. By the end of it, if I had said, "And isn't it true that the moon is made of green cheese?" he probably would have said, "Yes, Mr. Small, if that's in my statement, that's what I said." Defense counsel tried a couple of objections, but they could do nothing to stop the train wreck that their much heralded bridge witness had turned into. And all of it not from any particular skill of mine, but from lessons learned from others. The 3 C's: commit, credit, and confront.
Thank you for listening to the Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. For more information on courtroom preparation, please email dan.small@hklaw.com or visit hklaw.com/Daniel-Small.